Good morning, kia ora, god morgen to the people from Scania and Volvo. I think buongiorno to Iveco, bonjour to our friends from Keolis, and I'm sure we have other nationalities here. It's fantastic to see such a great and diverse group of people here, and what a wonderful night last night put on by Volvo. Went off with a bang, put on by Mercedes, my apologies. To the three-pointed star, my apologies. Went off with a bang, fantastic. So when Ian asked me first to get up and present today, I was a little bit challenged. I thought I'd been sold a pup. Innovative workplace practices. I wasn't exactly sure where Ian wanted me to go on that, but he clarified it by saying, you know, what will our challenges be in IR in 2025? Traditionally, industrial relations has revolved around employers engaging with unions. That traditional position is changing. As I understand it, the perception in the last 15 years, the reality in our business is that union membership has been diminishing. Some stats from the Australian Bureau of Statistics make interesting reading. Between 1992 and 2016, the proportion of employees who are trade union members dropped from 40% to 15%. 35% to 16% for females and 43% to 13% for males. As of August 16, 38% of union members worked in the public sector and only 9% worked in the private sector, and 21% of members were aged 55 to 59, and 88% of those had been union members for a long time, for over 5 years. So there are some statistics there that are representative of our workforces. As we know, most of our workforce is an aged workforce. Most of our workforce is 40 years of age and older. Therefore, some of those statistics are quite relevant to us. However, while I'm not necessarily suggesting there's a connection to declining membership, there's also, over the last 5 years, there's been an increase in the number of registered agreements which are being sought to be overturned. In addition, the number of registered agreements that are being registered have dropped. In 2013-14, there were 5,602 enterprise agreements registered. That number fell the following year to 5,027, declined further in 2015-16 to 4,523, and rose slightly in 16-17 to 4,663. So that represents a 17% decrease in the number of people who are registering registered agreements. Over a similar period, the number of employees who are covered by modern awards increased from 15% in 2010 to 24% in 2016. Enterprise agreements and bargaining have been the cornerstone of the union movement's business model. Therefore, the undermining of the model is concerning to the union movement, and they're diligently working to create different spaces. The concerns of the unions over diminution of their influence is reflected in Australian Council of Trade Unions' industrial relations agenda, which includes all employees, such things as changes that all employers are entitled to union membership in disciplinary proceedings, whether a member of the union or not. Union delegates should have the right to investigate disputes over payments, including access to workplaces and the power to require production of relevant documents by employers. They want the ability to undertake sectoral or industry-wide bargaining, a return to the old collective bargaining process, and agreements should only be made with unions representing workers. Last Thursday night, the ACTU Secretary Sally McManus, in a speech delivered to the John Curtin Research Centre, suggested that enterprise bargaining was a failed system, that it had exhausted its productivity benefits and was now about competing on wage costs. McManus suggested that bargaining had now become an almost ritualised period of conflict over wages or fights to resist the pressure for further wage cuts and job security. So against that background, what are some of the challenges that we might face over the next 5 to 7 years? I think with the reduction in union membership and fewer members in our workplace, you have to start questioning how much relevance and weight you give to issues being raised by unions in your bargaining. The unions will always have a place at the table, at our bargaining tables, because it's legislated that they can. But the question is, how many people do they represent? If you take those statistics, our workplace of 100 people, any of our workplaces that might have 100 people, you could suggest that there might only be 10 union members out of those 100 people. Therefore, how do you know when bargaining whether you're actually getting an agreement that is representative of the wishes of the majority of your workforce? I think progressive employers will find that they will start engaging directly with their employees. Anyone who had the fortune of attending the conference last year in Hobart would have heard Grace Collier talk. She was a great advocate of engagement by employers with their employees. It's an interesting phenomenon that even though we work with these workers every day and they're our most important assets, when it comes to a period of bargaining, they tend to be the last people that we actually speak to. In actual fact, they should be the first people, the middle people and the last people we speak to at all times. Progressive employers will find they'll experience greater benefit through individual engagement. They'll get more leverage in relation to the information that is relevant to employees. It turns more to an interest-based bargaining, so a lot of the times what employees are looking for is not necessarily more money, but some flexibility and other sort of flex in their work terms and conditions, some various accommodations and rosters and things like that. So you might find that by having direct engagement with your employees and spending a lot of time prior to a bargaining process starting, going out into your workforce, talking to your employees, making a list of the items that they find significant, will greatly assist you in relation to your upcoming bargaining. I think the other spin-off that comes with that is because you're engaging directly with your employees, you're communicating more with them, you end up with a greater level of trust being built up between you and your employees, and that, I think, leads to greater relationships and a better sort of working environment in the long term. I think the next thing was something that Tim touched on briefly, but I think is something that I'll spend a little bit more time on today, just so you have a little bit better understanding of this decision. I think the decision in Skane and WorkPac is slightly sort of distorted and become very, it's necessary to drill down to it so that we can see that perhaps it's not of the huge concern that we thought it might have been, but certainly something we need to be aware of and take into account when we're doing what we're doing. So, what did the Skane decision find? The Skane decision didn't find that casual employees are entitled to be paid for untaken annual leave, which accrued whilst they were working. What the Skane decision did find was that if an employer designates someone as a casual and that employee actually works the equivalent of a full-time employee, then the employer might be liable to pay benefits that accrue to a full-time employee. Skane is not a unique decision. There are a large number of cases that have been decided over the last few years, and going back to actually 1934, dealing with casual employees, what it means to be a casual employee, what their entitlements are. Skane was not a groundbreaking decision in that sense if you look at it for the facts, its own individual facts. And one of the things that came out of this decision and comes out of all the other decisions, that in relation to looking at a legal question in relation to a casual employee, they will look at the individual circumstances of each particular case. There's not one size fits all when it comes to casual employees. So, April 2010, Mr. Skane was employed by WorkPac, who are a labour hire company, as a casual truck driver in a central Queensland coal mine. He was initially a drive-in, drive-out employee, so he lived in southeast Queensland. He would drive 6 hours to the mine where he'd work and then drive 6 hours home. After a few months, he started to look for a fly-in, fly-out position, and WorkPac actually were looking for drivers for the Claremont coal mine, and which was a fly-in, fly-out role. So he applied and he was successful, and he commenced that job on the 16th of July. Now, what were the terms of Mr. Skane's employment? Well, he signed an engagement letter which said he was a casual employee. He was paid a flat rate of $50 per hour, which increased in April 2011 to $55 an hour. The rate of pay made no mention of what portion of that pay represented an amount of casual loading. So flat rate, no mention of casual loading. His ordinary hours of work were a standard work week of 38 hours, with an expectation that additional reasonable hours might be worked. The engagement was for 3 months, but that may vary, and it was a guide only. So he started work on the 20th of July, and at his induction at the Claremont coal mine, he was informed that his work would be 12.5-hour shifts on a 7 days on, 7 days off continuous roster. So he worked on the same crew from the day he started until when he was terminated, and they worked shifts, a day shift from 6:30am to 7pm, a night shift from 6:30pm to 7am. He was given his roster when he started work out to December 2010, and in January 2011 he was given his roster for the next 12 months, and in January 2012 he was given his roster for the next 12 months as well. He was given camp-style accommodation at the mine and was allocated the same room after his first 2 rotations. So as soon as the employer realised that this was someone we want to keep, he ended up with the same room each time. He worked 7 days straight on each day of the week, and he worked public holidays when they fell on a scheduled work day. He was paid weekly. So he worked 7 days, was off 7 days, but he was paid weekly. He was paid 62.5 hours in the first week and for 25 hours in the second week. When he was not required to work and was stood down, so when there wasn't coal to be hauled, then he was stood down, but he was still paid. So on the 23rd of April 2012, he attended a meeting with his supervisor in relation to discuss allegations made against him of adverse conduct, and his employment was terminated the next day. Now, who in this room feels, based on that set of engagement and working conditions, who believes that Mr. Skane was a casual employee? We get a show of hands if anyone believes he was a casual employee. Okay. Well, why do you think he was a casual employee?
Because he was engaged and paid as such, and we should be arguing that for
Well, okay. I respect your view. In fact, it was the view that WorkPac put. They suggested that within the industrial relations system in Australia, it's well recognised an employee is regarded as a casual employee for the purposes of identifying and calculating their paid annual entitlements if he or she is described or defined as a casual employee under an applicable federal industrial instrument. So WorkPac had the equivalent of an enterprise agreement under the previous work choices. It referred to casual employees, his letter referred to casual employees, so WorkPac argued that he is a casual employee. So effectively they said if there's an enterprise agreement or a modern ward and it says there's a status or a class of employees who's casual, if you call your employee a casual, then he's a casual. Unfortunately, the reality is that the judge in this case and the full court didn't agree with WorkPac, and they relied on a long line of authorities over a long period of time that basically set out that just because you call a casual is not necessarily a casual. Now, for all those who don't know where Claremont is, there's a picture of Australia. I found this quite interesting. I wanted to know where Claremont was. I wasn't sure. I thought I did and was up there in central Queensland. So, and there in fact is a picture of the Claremont coal mine. If you look down at the bottom left-hand corner, it's a pretty ugly bit of work, isn't it? Big hole in the ground, it's just an open-cut mine. That's where Mr. Skane got his accommodation when he was there on his 7 days on and 7 days off. Of course, in doing my research, I found something else fairly interesting about Claremont. Can you see it? It's a very picturesque view, that's true, and it's not the silver ute in the foreground. Some innovative and very industrious person in Claremont came up with a fantastic idea on putting Claremont on the map. And they whacked a piano in a tree. And if you Google Claremont and go there on Google Maps, you've got to go into satellite. You can't do it on, and you don't reach your mobile phone and try and do it on the phone, because I tried that and it doesn't work. You've got to be on your computer. And it comes up and it's got piano in a tree. And it's right there, and and what has that got to do with Mr. Skane? Nothing, apart from the fact that it was in Claremont. And, industrial relations talks are inherently boring, and I got told by everyone I had to make some jokes and make it funny. So I had to find a way to weld something in to try and sort of lift, about halfway through the talk, to sort of lift the spirits. Anyway, so what the court decided was the essence of casualness referred to an absence of a firm advance commitment as to the duration of an employee's employment. So the characteristic that distinguishes full-time and part-time employment from casual is that that employment was ongoing or a permanent. Casual, full-time, part-time and permanent has that ongoing nature, a permanency about it. And, it provides an employee with a continuous and indefinite employment according to an agreed pattern of ordinary time. So, and there's a corresponding commitment from the employee that they're going to turn up and work their shifts. We know with a casual, there's no guarantee of engagement from one engagement to the next. They're essentially there as a backup where you have a full-time person who can't sort of slot in, or where you have extra hours that don't justify engaging a full-time person. So in contrast, a casual employee has no firm commitment from an employer to continuing an indefinite work or an agreed pattern of work. And the casual employee has no obligation to a reciprocal commitment to the employer to turn up when asked to do so. So when you look at the reality and the circumstances of Skane, he was called a casual employee, but in actual fact, all aspects of his engagement and all aspects of his work really were indicative of full-time, giving a 12-month roster in advance, expecting to work 7 days on, 7 days off. There was an expectation that he would turn up and perform his work under that roster. You know? None of those go to a casual engagement. So the essence of casual employment was totally missing in Mr. Skeen's employment. His pattern of employment was regular and predictable. It was continuous. It was not subject to significant fluctuation. And it was done in circumstances where there was plainly an expectation that he would be available on an ongoing basis to perform the duties required of him of his roster. So, I don't think we should be panicking about the decision in Skeen, because you can see from those circumstances the decision that the court arrived at could be arrived at from a very logical sort of view of what was going on in that case. I think casuals have a very important place in our industry. I think there are probably a lot of us, a lot of operators out there who do school bus runs who might be a little bit concerned as a result of what the decision in Skeen. I really don't think you need to be that concerned in relation to it. I think the nature of things like school bus drivers lends itself to casual employment, has all the factors and aspects that support casual employment. The other issue in relation to casuals, which has been topical of late, is casual conversion. Oh, I missed my big point. So, with Mr. Skeen, the thing we have to remember is if it looks like a duck and quacks like a duck, it is a duck, all right? So, if you're going to work them full-time, it's going to be full-time. They're going to be entitled to full-time. Casual conversion. So, as of the 21st of September 2018, casual conversion clause has now been introduced into the Passenger Vehicle Transportation Award. All employees are required to be advised of this. Any employees working under enterprise agreements are required to be advised by the 31st of December of their entitlement to seek casual conversion should they fulfil the criteria within the award. I just want to look at casual conversion today simply from a position of will it have a substantial effect on our wages, on the wages that we pay. So if we have a substantial number of casuals who suddenly want to seek to exercise their entitlements under the casual conversion, are we going to suddenly suffer a financial crisis in our business? I've done a couple of scenarios which I'll put up on the screen. I'm going to put a few qualifications on this from the outset. I don't work in payroll, so please don't hoist me on the petard if I get anything wrong. I've done it based on the award and award rates of a equivalent of a full-time grade 3 driver, and I've done a comparison of casual v part-time, and there are two scenarios. So firstly, what I've done is looked at a casual bus driver working 20 hours a week. So your typical bus driver who works 2 hours in the morning, 2 hours in the afternoon, taking kids to and from school, and only during school terms. So we're talking 40 weeks of the year. So pretty simple. I've paid him his straight rate, $22.11 for the 20 hours with his casual loading of 25%. I've given him a first aid allowance as well based on the standard rate, and that comes to a total of about $561 a week, 35. These are all gross figures. Compare that to a part-time school bus driver, the same driver who decides I want to go part-time, still working 20 hours a week, only paid the flat $22.11 of the award, so his weekly total there is $442.20. is entitled to first aid allowance, so he gets the same amount. He also made allowance there for a portion of personal carers leave that he's entitled to, and annual leave accruals. I think I've worked out that at 20 hours he'd end up with somewhere in the order of about 8 days entitlement to annual leave. So it's broken down into a weekly portion. So the amount there is $472.87. So there's a difference between the casual school bus driver and the part-time school bus driver. The part-time driver takes home $88.28 less per week than a casual. Just by comparison, I've then compared a casual employee working 38 hours for the reasons I've just mentioned in Skane. I'm using this for example only. I don't recommend that you follow this example. And I believe this is recorded, so I will be able to come back to defend myself if any of you say otherwise. So we have a casual employee working 38 hours with the 25% loading. He's got his first aid allowance again. He's not entitled to any other allowances or annual leave. So his weekly total, gross total there is $1,066.19. Compare that to a part-time casual employee doing 38 hours a week, and you'll see that even after payment of the additional allowances, etc., the part-time employee is receiving $964.42. So he's actually receiving $101.77 less than the equivalent casual driver. Now, I haven't done superannuation, I haven't put other sort of things in there because those entitlements remain the same. There's the entitlement to super at whatever rate you're paying, so it doesn't really influence where those figures are. So I guess the point that I wanted to underline there is my belief that casual conversion may not be the challenge to our businesses that a lot of us may have feared that they would be. I think most of our drivers work and live on their wage from week to week, and they will want to ensure that they take home the largest amount of pay they do each week. So in a scenario where that amount is likely to change, I think they're going to have a challenge as to whether they accept that or not. I had a couple other things that I'd touch on pretty quickly. Other potential challenges to us: individualism v unionism. We have a lot more individuals now representing themselves in bargaining. The challenges that brings with their individual views and looking for accommodation on their own individual issues as opposed to union issues. Millennials in the workforce. Can you imagine? Just doing Route 823, catch you at the next stop. Post. I don't know, with our mobile phone policy, I don't think we would end up with any millennials working for us. So I don't know whether that means we need to change our mobile phone policy or whether or not we'll just continue to employ people who aren't sort of fully connected to their mobile device all the time. Flexible work arrangements, more and more flexibility is being sought, particularly given our workforce is made up of a lot of people who are grandparents and who have millennials who are entering the workforce and can't possibly juggle a job and looking after their kids and daycare and everything else. They'll be calling on grandparents to sort of come and assist them more. So we're going to have the challenge of flexible work arrangements, how we can accommodate that. Driver safety, certainly an issue being driven heavily by the union movement, something we really need to sort of look at, and particularly in relation to driver safety relating to our female drivers. We probably are disproportionately underrepresented as a portion of society by the number of our workforce. We tend to be a fairly, the drivers in particular, tend to be a fairly male-heavy workforce. However, there are certainly a lot of statistics coming out of mines where they have female drivers driving the big trucks and everything on the mines, that they're finding that the female drivers are far gentler on the machinery. They have far less issues, they have far less wear and tear and maintenance in relation to that. So obviously, we're driving, buses are a big piece of kit. They require maintenance, and if we can find one way to minimise some of those sort of costs and expenses, one way we might be able to do it is encouraging more women into our workforces as drivers, and in order to do that, I think we also need to first address the safety issue so they feel safe. So I hope that's giving you a little bit of guidance. Obviously there are some challenges ahead of us, but I don't believe that it's all doom and gloom. Thank you.